Buckle up, guys. Today we're stepping into a courtroom moment that instantly tells you how this is going to go. Right from the start, Leonard Black comes all confused, dodging basic questions, and completely unprepared, struggling just to get his camera and mic working. You can almost feel the judge's patience getting tested early, while the commentator hints this isn't even his first time on Zoom. It's an awkward, slow-motion start that quickly builds tension, making it clear this hearing won't be about legal strategy. It's going to be about excuses.
Okay, well, can you activate your camera so I can see you?
I'm trying to. This is a new phone, so I'm not familiar with it. I can't see anything more to activate the camera.
Well, go down in the lower left. There, you've changed it. Did you do that?
To start my video.
On the lower left screen, you should have a little. There, I think you're going to come on here in a second. Yeah, there you are.
You see me?
Hi there.
Okay, I don't see me, but
I see you. And did you maybe? No. Okay, so I need you to unmute, Mr. Black. Click on your microphone. Mr. Blatt, in the lower left corner, there's going to be a little silhouette of a microphone with a line through it. You need to click on that. I can't hear you until you do that. I can't hear you. You've muted your microphone. You need to unmute it.
Okay, can you hear me now?
Yes, I'd like to be able to do both, hear you and see you.
Can you see me? Can you hear me?
I cannot hear you. I can hear you, but I cannot see you.
Shit.
I heard that.
Sorry.
There you are.
Okay, can you hear me?
I can. Can you hear me?
Yes.
Perfect, and I can see you, so don't change a thing.
All right, I won't touch it.
So there's a motion on the calendar here. You're representing yourself, correct?
I am myself. I'm in
know.
propria persona.
I'm sorry?
I'm in propria persona.
Okay,
I
well,
am
in any
myself.
case, you don't have an attorney and you'll be running your own defense. Is that what you're
Okay.
telling me?
Yes.
Okay. And so the state's asked to, or is this a state? The city of Tumwater is asking to continue the trial. Did you see that motion?
No, but I'll take your word for it.
Thank you. But I will tell you what the substance of the motion is.
I have to explain this in the last hearing. I was poisoned by insecticide. I bought anti-flea spray for my dog, and it said non-toxic on it, so I sprayed it all over the house and my bed and my clothes, and it knocked me out for 2 weeks, and I still lose my balance sometimes. It was really poison.
Okay.
Once they finally get communication sorted, things don't exactly get better. They get chaotic. Black confirms he's representing himself, then immediately jumps into a strange story about being poisoned by insecticide meant for his dog. The judge listens, but quickly brings things back to reality. Focusing on the state's request to continue the trial, Blatt objects, clearly not grasping what that means, but the judge calmly breaks it down and grants a continuance anyway. It's a clean display of authority, while Blatt slowly loses control of the situation.
I'm sorry to hear that. But here's where we're at on the trial. The state filed a motion. Let's see, right now, trial is set for confirmation is October 22nd, in 2 days. And then the trial is set for October 29th and 30th. The state's asking to move that because they have a witness issue. One of the police officer apparently is not available in that time. And so they want to move the trial maybe a week or two. And I guess I would get your position on that request.
Well, what'll happen if I decline that, if I object to it?
Well, then they're asking, then I get to decide whether or not the state has shown good cause to continue the trial or not. And then one of two things can happen, I guess. You're objecting, I can sustain your objection, not continue the trial, and then the state would probably be out of luck. Or I could find good cause because a material witness is unavailable, and then I can go a little bit beyond when speedy trial is to allow the trial to take place with the state's witness. And I can tell you a couple of things. One thing that this is a fairly common occurrence from both the defense and the state. And if the defense comes to me and says, hey, look, I need these witnesses to defend my case, but they're not available, can we move the trial? I'll generally accommodate that. I'll let people put on their defense. But the same is true for the state. If they have a witness, and I think who is material to their case, and they can't proceed without, I'll give the state some leeway to find good cause and reset the trial to when the witness can appear. So that might be a spoiler alert, but it's up to you. You don't have to agree. No one's asking you that. I'm just asking, I'm telling you what the state's asking. I'm telling you what generally happens in situations like this. And I'm just asking for your response, and then I'll make a ruling.
Okay, if you deny the prosecution's request, then the trial would be held in 2 days?
No, the trial, I don't know what would happen if they denied the state's request. Then if the state can't proceed, they can't. But I think
Okay.
I kind of hinted that generally I grant this type of motion, but because I want to be upfront with you. But it's
Yes,
up to you as to how you want to decide.
Well, I object to their motion.
All right. I'm going to find good cause to continue the trial because of the state's unavailability of a state's witness. I'm going to ask Ms. Kidmacher when's the soonest available date that you can be ready and have a trial, and I'll set it for that date.
Your Honor, my understanding is the officer is unavailable through November 8th. Other than that, I don't have notes as to other unavailable dates.
So what we're going to do then, Mr. Blatt, we're going to set the trial for November 17th and 18th, and then we'll have confirmation on November 12th, which is a Wednesday in the afternoon.
May I ask something?
Yes.
As I understand, the hearing I missed was the motions hearing, right?
No, this is the motion hearing.
Okay, I'm not prepared because, as I said, I was sick and I'm still recovering.
Well, then you should ask for a continuance. Just try not to eat any more bug killer between now and then.
No, but
Can't
the
be-
motion is, hang on just a second, the motion is to continue the trial. And I've already asked you what your response to that is.
Oh, so it's the prosecution's motion, but I also
Yes.
didn't I also notice the motion hearing?
Okay, we can renote that if you want. I didn't see that. That's not
Yes,
what I'm
please.
here for here today. When did you ask for that motion hearing to be held? Oh, I see.
Your Honor, at the hearing back on September 3rd, I see a note for a motion hearing set for today. The defendant must file his motion no later than October 6th.
Well, that was me.
State-
Yeah, did you ever file anything?
I don't think so because, like I said, I
Because you were
was
sick. I get it. Yeah, all right. Well, you're still free to. Well, do you want that motion heard?
Yes, please, but not.
You better file it. I mean, you were supposed to file something by October 8th. We didn't get
Right.
anything.
Right. Can we reset that and the deadline for me to submit the motions?
Yes, we can do that, but we'll probably, in order to accommodate that, we're going to have to move this trial out a little bit further.
Okay, past the speedy date?
Yes, it's already past the speedy date based on my
Okay.
finding of good cause because of the state's material witness unavailability. I can,
Nice.
at your request, if you want your motion heard before that, I'll accommodate that, but we're going to have to mess with the dates a little bit.
Okay, I'll waive speedy trial rights for that.
Well, I don't even think we need to get there. I can make findings. Okay, so let's forget those dates. Let me redo these dates here. Well, let me ask you, how are you feeling now? How quickly can you get your motion together?
I'm doing okay. Like I said, I lose my balance sometimes, but I'm getting better.
I'm just asking you for a time limit. How much time do you need? I'll give you the time you need. I just want to know how much you
1
need.
week. 1 week.
All right.
1 week.
So hang on just today. Let me take a look here.
And Your Honor, I'm not sure what type of motion or whether it's going to be something that requires officer testimony, so I would just ask that it be.
My guess is if it's constitutional grounds. If you need officer testimony, you can ask to reset it. But I just,
I would ask that it be set after November 8th.
all right. Because the officers.
Correct.
All right, so we're gonna set a motion hearing for November 10th. All right,
Yes.
you need to have your motion filed by October 27th. It's a week from today, so you have a week to get your motion together. You got to file by October 27th. The state needs to get their response in by November 3rd. And then the motion will be heard on November 10th. Why don't we just do a confirmation for that date also? And then I already moved the trial date to November 17th and 18th. We'll just leave that date. And then the confirmation will be the same as the motion hearing date on November 10th. And if he's successful, then we'll do it that way.
And you said trial 17th and 18th.
What's that? 17th and 18th. Okay, so do you understand where we're at?
Yes.
When do you need to have your motion filed by?
The 27th, 1 week.
Right. And then the state by the 3rd, we'll see everybody back here on the 10th.
Okay. Thank you.
Hang on just a second, I have another question for you. Have you been getting text reminders of court dates?
Yes.
Great. We'll see you back here, and then this will be excluded from speedy trial calculation. I'll make that finding based on the witness unavailability and to accommodate Mr. Blatt's ability to get his motion in.
Now the court resets timelines, explains deadlines, and tries multiple times to get Blatt on the same page. He claims illness but never filed the proper motions, then asks for more time as if that alone fixes things. The judge still gives him room, setting clear expectations and warning him about speedy trial rights. What stands out here is a contrast. Steady patience from the bench versus constant confusion and disorganization from Blatt, ending with the court moving forward no matter how lost he seems.
Pleasure to be here.
Mr. Blatt, you filed various motions to dismiss the driving with suspended license third degree against you. I've read all of it, and we are getting kind of late in the morning here. Is there anything you'd like to say that is different from what, or you'd like to highlight from the?
Well, first, may I ask the court to identify yourself and the prosecutor?
Certainly, I'm Court Commissioner Jacobs.
Prosecutor today is Ford Libby, Rule 9, supervised by Rosemary Fitzgerald.
Yes. When the officer stopped me, he asked me for paperwork, and simply accused me of a paperwork violation. He asked for 3 things: license, proof of insurance, and registration. Anyone who's engaged in a potentially hazardous activity like operating a motor vehicle has to have his paperwork in order, especially insurance, because he can cause damage with his car. Same thing is true with yourself, because being a judge is a potentially hazardous occupation because it involves violence. No one can be put in a jail cell without unwanted touching, and a lot of damage can come to people if a judge does something wrong. And as a person who has been through family court and witnessed how unprofessional and out of control the judiciary is here in Washington, and I think you know that the reputation of the legal system in Washington is very bad. I mean, even at one point, the federal government had to come in and supervise and babysit the police because they weren't being controlled.
So I'm going to just try to frame what I'm looking for. Because again, I did read what you read, and so maybe it would be helpful if sort of I outline my thinking here. I'll give you a chance to respond. I'll give you a chance for the city of Tumwater as well to weigh in here. But let me just kind of start where I'm at.
Sure.
All right, because I know a lot of your arguments are sort of based on sort of overall authority to enforce these laws against you. So I'll sort of start there. The Revised Code of Washington, which is the state legal code that is applicable here to criminal offenses related to driver's license. It provides at RCW 4620-342 that it's unlawful for anyone to drive a motor vehicle in the state while the person has a suspended or revoked driver's license. The allegations against you is that you were driving a motor vehicle on a public road with a suspended driver's license. There's still allegations against you that hasn't been proven. But but the city of Tumwater is within its authority to pursue that prosecution because you were allegedly driving a car with a suspended license. And so I know you've raised a number of concerns around that, one of them being you have the right to travel. You don't have a right in any particular mode of travel, so driving a car does trigger certain legal requirements.
Excuse me, I've been in this court already, I think it's the 5th time, and each time I've heard the judge make the arguments that the prosecutor is supposed to make. In other words, the judge has been prosecuting.
The second hearing kicks off, and Blatt switches strategies, but not in a good way. Instead of dealing with the charges, he starts questioning the judge's authority, asking for identification, oaths, and bonds like he's uncovering some hidden loophole. He even compares driving laws to judicial licensing, suggesting judges are somehow more dangerous than drivers. The court listens but firmly pushes back, explaining the law while Blatt doubles down, and accuses the judge of acting like a prosecutor. You can feel the tension rising as his arguments drift further from reality.
May I get back on track, because I was making a point. I was heading toward a point when you asked to interject. Okay, so we need to take care of some preliminary matters first. Just as I had to produce paperwork when an officer saw me what he believed to be engaged in privileged activity, you need your paperwork in order too, and I just need to verify that your paperwork is in order. I am eager to argue my motions, and I'm eager to hear the prosecutor's response. But first, we need to know if you have your license to operate, which is your oath of office. That's analogous to a driver's license. It's because nobody has a right to be a judge, it's a privilege. And also your bond, your official bond through a surety company is analogous to insurance for a driver. Because if I'm injured in the course of these proceedings, I need to know that I can be compensated. So
you are welcome to file a public records request asking for any documentation you found with my authority as the court commissioner or anyone else involved.
Right, and I couldn't do that because I didn't know who would appear today as a judge. I mean, I asked before and I couldn't get a clear answer. Also, your bond is supposed to be filed with the county clerk. And with your permission, I mean, I want to make it easy for you. Don't want to make you produce it for me. I could go around the corner to the same building here and verify that your bond is filed with sufficient sureties.
So we're not going to do that today for relevancy purposes here, because what's relevant here is not anything related to me. It's related to allegations against the driver.
It absolutely is relevant to you, because it's all about whether you have jurisdiction, and you don't have jurisdiction without your oath of office timely filed and a bond with sufficient sureties. And I have a pocket brief here that I'll give you the court and a copy to the prosecutor to show you.
I'm going to stop you again, and I don't mean to interrupt here, but you have the opportunity to look at those documents. If you're able to find documents in any way indicating that we don't have the proper authority here to operate as a court in this case, you're welcome to get those documents and present them. But we're not, during the course of the prosecution, going to chase down every indication without any supported evidence that something's amiss. So if you have something through a public records request, you're able to bring it, but we're not going to chase down all of those arguments as they pop up. We're not going to play whack-a-mole necessarily with arguments being made without evidence.
So if I told the officer who stopped me that I have a driver's license, I have insurance, trust me, it's your job to go look for it, not mine to produce it, what do you think he would have done?
Blatt leans all the way into it now, reading statutes out loud, insisting the court has no jurisdiction, and claiming public records prove the judge lacks authority. Instead of presenting real evidence, it turns into a stream of scattered accusations. The judge keeps trying to guide him, explaining how motions actually work. But Blatt refuses to follow any structure. Interruptions pile up, time warnings start coming in, and you can feel the patience in the room wearing thin as everything begins to spiral.
I don't know. I wasn't there.
Well, we all know what he would have done. He would have said, that don't cut it.
So these are all comments that you made in your briefing. So I'm going to, again, remind you, I've read those arguments.
I'm going to give a copy of my pocket brief showing that the judge and prosecutor both require bonding and insurance. And with your permission.
If you have evidence that there hasn't been proper bonding, you can certainly.
Well, that's my evidence, my testimony here.
Well, you're not alleging it hasn't happened.
I am alleging it hasn't happened. I am alleging that. With your permission, I'll give the court a copy of the pocket brief I just gave to the prosecutor.
Sure. But then I'm going to turn it over to the prosecutor to have an opportunity to respond.
Isn't it my turn to present my motions?
Yes, and you have, and you.
No, I have not.
You have. You provided written motions. You've been given some time to sort of summarize the arguments that are here. So we also want to hear from both sides.
I need to make a statement for the record so the appellate court can understand.
It's 11:33. You got till 11.
Well, if the prosecutor wants you to take 3 months out of my life, you have to give me enough time because the taxpayers are going to pay for this. You see, when the officer first stopped me, it was mistakenly thought that I would pay the $66 fine or whatever, how much it is. And what's going to happen is the opposite. The plaintiff is going to house me, clothe me, feed me, take care of all my needs, medical needs and everything. And I'll get to watch television. I love to watch television. And I love to kick back and relax. And that's what's ultimately going to happen. But we're going to go through due process first. I won't be denied due process. So every district judge, this is RCW 3.34.080, every district judge pro tempore, and district court commissioner shall, before entering upon the duties of office, take an oath to support the Constitution of the United States and the Constitution of the State of Washington. And as far as bonds, every judge of a municipal court, before entering upon the duties of office, shall take and subscribe the following oath or affirmation. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of Washington. The judge shall also give such bonds to the state and city for the faithful performance of the judge's duties as may be by law, ordinance, or directed. The prosecutor's bond, every county official before he or enters upon the duties of his or her office shall furnish a bond condition that he will faithfully perform the duties of his or her office. Prosecuting attorney shall file it in the amount of $5,000 with sureties to be approved by the proper county legislative authority. Tumwater police officers also have to have a bond, and that's RCW 35A.12.080. As far as, so it's very, very important. It's not just a joke or something that's not important. It's very important that you have an oath of office on file, because from what I've observed in this court and many, many courts throughout the last 40 years living in this state, that judges hate to follow the Constitution. They despise it. So I need to ascertain that you have a timely filed oath of office. Now, I did make a public disclosure request for all the judges that might be operating in this court, and I have them here. I'm going to make sure your name is on it. I have a oath of office for a John Tunem. It's not you, right?
Remind you to tell 11:40. It's 11:36.
What if it takes longer?
Because sir, I'm telling you again, I've read what you've written, and you're frankly not you're allowed to speak, but unless if you have evidence, and if you have evidence there that you wanted to present to the court, you should look at it beforehand and then make an allegation.
I did.
You're reading through what you response to your public records act.
You said I should make a public disclosure request for your oath of office and bond, and that's what I've done. And here I'm going through it.
You should go through it.
Well, I didn't know who you were until I just sat down here. I didn't know who the prosecutor was.
Your Honor, I don't want to belabor the point, but just to make sure that we're being as effective as possible here, this just falls outside the scope of today's hearing.
No, it does not, because my brief addresses the importance of obeying the Constitution of the United States and the state of Washington.
I can tell you, I have my oath of office. I took it a couple of weeks ago. I'm over here, but I took it in this very room.
Well, I could not find it unless it's here, because I was given all the oaths of every judge that could possibly be working here. That's what I requested. I also have an oath of office for, it's John Tillum again. He gave me a few. As far as bonds, Joel L. LaPierre is supposed to have a bond. That's not you though, right? What is your bonding number? Okay, so before we can proceed, we have to take care of this preliminary matter.
That's not
Well,
You're welcome to bring evidence that I'm not a correct judicial officer for this, but again, we're not going to figure out.
well, you're supposed to prove it to me, just like I was supposed to prove it to the officer that stopped me, that my paperwork was in order before engaging in a privileged activity.
I certainly believe that, but that's not.
You don't, can you cite the law?
No, you're asking me to cite a law that doesn't exist. A judicial officer does not need to present their bonding papers.
But you need to have a bonding number, and we've determined that you don't. I requested the bonding information and the oaths of office of every judicial officer that could be working in this court, and they gave it to me all here, but your name doesn't appear to be on it. That's prima facie evidence that you don't have an oath of office or bond.
Well, then you can file a motion on that specific question. Like, you've got 2 more minutes.
Okay, I'd like to file that motion right now.
You don't have it. You gotta file a motion first.
I can make a verbal motion, I can make it orally. Do you want me to find the RCW, the statute that allows me to make it orally?
Sure, and then you can go and you'd have to, well, I can't give you legal advice, but.
You gave me a lot of legal advice today.
Explaining what the law is.
The prosecutor said nary a word.
We've been giving you a chance to speak. We've got 1 more minute.
Well, I have to determine whether we have jurisdiction here.
That's not,
Well, it's up to you, but you're not making a decision on it.
we do have jurisdiction. I'm telling you I have an office.
But that's not enough. Me telling the police officer I have a driver's license is not enough.
The allegations that you did not have.
Yeah, a surgeon telling his licensing authority, I have a license, without proving it is not enough. We have prima facie evidence here that you don't have an oath of office or bonding. And the Constitution, you say you have an oath of office? Well, that means you swore to uphold the Constitution. And the Constitution requires you to have an oath of office timely filed. And RCW Title 42 says if you don't have it timely filed, you're not lawfully in office. That means that you can't preside over this hearing.
And to the extent you want an answer right now, I'm denying that motion. If you want to file something in writing that goes into that in more detail, that's evidence that I don't have authority to do that. I don't know when you made your public records request. It might have been before I took my office. Out of time for your arguments.
How do you spell your name?
S-T-I-L-L
S-T-I-L-L-W-E-L-L.
W-E-L-L. First name Jacob Lewis.
Okay. I'm going to not participate in an unlawful hearing. So I'm going to go over to the clerk's office and try to get your oath of office and bond. And if they have it, I'll be back here and let's proceed. I'm actually eager to do so.
Well, you're going to have to file a motion. We're not going to probably be.
You don't operate after lunchtime at all?
The calendar's going to end at noon. So if you find something, you can file a motion, but we're not going to stay open to see.
Okay, well, I came here at 9 o'clock because I thought things would start then, and I had to endure watching all this.
We're out of time.
So that's what I'm going to do, because I'm not going to participate in an unfair hearing where there's no jurisdiction. I will file another
Final comments?
My final comments are this. We're going to assume that you don't have an oath of office timely filed or bonding, so you can't proceed over this hearing.
We'll
It's
get
simple.
evidence of that. You can come back, but until then, we're going to, unless the prosecutor has anything to say.
Okay, so then, since I object,
Sir, I'm giving it over to the prosecutor.
since I'm wait, I have a right to make my motions. I have a right to argue my motions. I brought this hearing,
I understand
not the
we're going to
prosecutor.
move on.
I brought this hearing, not the prosecutor.
We're going to move on.
So I'm going to ask you to recuse yourself, since you're not,
All right, well, if there's been a request for recusal, perhaps I won't be here at the next hearing, but that's going to be it for today. So we're also here set for trial confirmation. You have a jury trial set. Well, you don't have, the state is moving forward, probable cause has been found. You've elected to represent yourself.
I am myself. I don't represent myself. I am myself.
Well, are you ready to proceed to trial on November 17th?
First, I have to be advised of the nature and cause of action and enter a plea. And I have to verify that the judge, which keeps rotating, is lawfully in office. I mean, I'm not trying to throw monkey wrenches in this or anything or give you a hard time. I'm just trying to require due process.
You were arraigned on June 26th, 2023. Determination of
Your Honor, just to,
Well, you said I'm free to leave, and you're not lawfully in office, so I'm going to leave.
well, Your Honor, if the defendant's going to walk out, I would request a bench warrant be issued if he's just going to walk out of his own trial confirmation.
Sir, are you here with him? Is that the should be speaking? I was asking if the two of you were here together.
I can't hear.
Were you here with Mr. Black?
I don't have a case here.
Were you here with Mr. Black, who was just up here?
I can't really hear you. I'm getting a hearing aid.
Why are you here?
I haven't had all the tests yet.
Why are you here in court today?
Oh, I'm just here to observe.
With Mr.
Very
Black?
interesting. I watched the body language. I watched the behavior channel on YouTube, and I'm watching this video to watch the body language.
All right. Thank you,
Very
sir.
interesting.
Okay, thank you, sir.
Can I go
Feel free to
now?
go. Yes. All right.
In the final stretch, Blatt basically checks out. He refuses to participate, calls the court unlawful, and even tries to walk out mid-hearing. The judge shuts down his verbal motions, explains jurisdiction one last time, and makes it clear there will be consequences. Blatt leaves anyway, forcing the court to consider a bench warrant. The video wraps with commentary pointing out that this isn't the last we'll see of him. If you like the video, hit like, subscribe to the channel, and I'll catch you in the next one.